Welcome to the Law Office of Hieu's YouTube channel. Today's topic is both crucial and highly relevant for many people: civil demand letters in the context of shoplifting. If you've ever been caught shoplifting or know someone who has, you're likely aware of the criminal charges that follow. But what about the civil repercussions? Specifically, the civil demand letter you might receive in the mail. This video will provide an overview of what these letters entail and how they differ from criminal charges and your best course of action. When you're caught shoplifting in Orange County, you may face charges at the local courthouses like Fullerton, Santa Ana, Westminster, or the Newport Courthouse. But alongside these criminal charges, you'll likely receive a civil demand letter from an attorney, as well as communication from the Orange County District Attorney's Office. This is where things get complex. A civil demand letter is essentially a claim for compensation from the merchant you shoplifted from. California law permits them as a means for retailers to recoup their losses. But this is where it gets tricky. Often, the items are recovered, meaning the merchant hasn't really lost anything. Despite this, you might still receive a demand for an amount typically around $500. It's a practice that many argue is unfair and unrealistic. For example, if you got caught stealing a $75 item, does it really make sense for you to pay $500? Where is that profit going to? These laws are designed to make up for losses, not for the purpose of profit. Now, it's crucial to understand the distinction between civil demand letters and criminal charges. They are not the same. Many people mistakenly think that paying off the civil demand letter will clear their criminal charges. This is not true. Paying the civil demand letter has no bearing on your criminal case, and ignoring your court date could lead to an arrest warrant. I've had many people call me and say that I got caught shoplifting. I paid a fine, but somehow I got a warrant. What really happened was they got caught shoplifting and they had a criminal case and they had a civil demand letter. And then they paid a civil demand letter thinking that it would make the criminal case go away. After they paid the civil demand letter, they were under the assumption that their criminal case had gone away, and then it did not. They had a missed court date and an arrest warrant was issued for them at the local courthouse. The process of receiving a civil demand letter is relatively straightforward. It doesn't happen immediately after the shoplifting incident. Usually it arrives a few weeks later, often before your court date, and includes a warning that failure to pay may lead to civil action. But proving actual loss is challenging for merchants, especially when they've recovered the stolen property. Retailers and their legal representatives often follow up aggressively in these letters. If you ignored it, you might face civil actions. However, proving damages is difficult for the merchant, particularly when they're recovered their property. Not responding to a letter could result in a civil judgment and potential attorney fees, but these are possibilities and not certainties. My advice to clients is generally not to worry too much about the civil demand letter in shoplifting cases, as payment does not affect criminal cases. However, there are instances where paying the demand could lead to a dismissal or a civil compromise in the criminal case. This is where the role of a criminal defense attorney becomes vital. They can manage the civil demand letter for you, negotiate with the company, and provide guidance. They prevent civil attorneys from pressuring you into paying unnecessary fees, especially if the stolen item has been recovered. Additionally, they can help avoid a criminal conviction for petty theft, Penal Code 484 shoplifting charge. A civil attorney with experience in shoplifting cases can only effectively handle these non-criminal issues. A criminal defense attorney with experience in shoplifting cases can effectively handle these non-criminal cases. They can reach out on your behalf, express your disinterest in paying, and designate themselves as your representative if a lawsuit is filed. Knowing that you have an attorney often deters firms from pursuing further action. In conclusion, the legal and financial repercussions of not responding to a civil demand letter include the risk of a civil lawsuit and the potential for several $100s in liabilities and attorney fees. It's a complex area, and having an attorney who understands the nuances is crucial. Thank you for watching, and remember, for more legal insights and advice, don't forget to subscribe to our channel. If you like the video, give me a thumbs up. If you have any questions, you can leave a comment in the comment section below or give our office a call. You can also use the make an appointment button. Stay informed and protected. Thank you for watching.